Good day, Crime Talk aficionados. It's Saturday, December 25th, 2021. That's right, it's Christmas, and we're still bringing you the Crime Talk weekly recap. Hope you have a wonderful day. We'll see you next time on Crime Talk. Now, first on the docket, let's talk about the 110-year sentence that has everybody talking about it as to whether it was fair or whether it was unjust. So for those of you who do not know, Rohel Aguilera-Mederos, he was convicted for a truck accident that was a terrible truck accident. And it was when he was coming out of the mountains here in the Denver area on I-70. Take a look at this video that was taken by somebody behind the truck that was allegedly driven by Aguilera-Mederos. And as you can see, he clearly misses a runaway truck ramp. He almost takes out another car as he moves over to the left-hand lane, and he continues to go down this stretch of road. And if anybody has ever driven this stretch of road on I-70, which I have, is people go down it quickly. Trucks should be going down it slowly. It's not uncommon to smell the odor of brakes being heated up by big semis. It happens, hence the reason for the runaway truck ramps. So, as a lot of people may not know, Mr. Aguilera-Mederos was charged with 4 counts of vehicular homicide. Those charges seem to make sense in this particular case. But he was also charged with first-degree assault, which carries mandatory minimums, as well as attempted first-degree assault cases, which also carry mandatory minimums. The mandatory minimum sentences in this case is what got Mr. Aguilera-Mederos the 110-year sentence. The judge stated on the record, and it was true, that his hands were tied due to the fact that under the mandatory minimum sentencing, and you have separate victims, so those charges have to be run consecutive after another. That's why they got to 110 years. For example, the first-degree assault charge carries 10 to 32 years with a mandatory minimum of 10 years. Times 4, you got 40 years right there. The attempted first-degree assaults, well, that carries 5 to 16. Boom. As you can see, this starts adding up very, very quickly, and that's how he got to 110 years. A lot of people, roughly 4 million people, have signed a petition to have the Governor Polis, impose some clemency on this particular case and reduce the sentence. There are some mitigating factors in this particular case. Mr. Aguilera-Mederos did not have much driving experience in the mountains. It's something I would think most professional truck drivers could do, but you would want to be very cautious. There's also the issue of the maintenance of the vehicle. There's some evidence that Mr. Aguilera-Mederos knew that his brakes were not in the best quality, but he proceeded anyway. And then you have all the other things with the Mr. Aguilera-Mederos could have done. When he was approaching, and as you can see from the second video of a dash cam, you can see the truck going by before it literally plows into parked vehicles that were there because of an accident or some delay underneath the bridge, and literally striking these vehicles where 4 people died, many more injured, and those that died, most of them burned to death. So a lot of people are calling this simply an accident. But remember, the term an accident implies that events totally outside the driver's control led to the crash. Was it unintentional? Well, probably was not intentional, but he clearly was negligent by failing to see the runaway truck ramp, to take advantage of the runaway truck ramp, and then perhaps going off to the side of the road of the highway versus using parked vehicles to come to a stop. Like I said, you can see this fiery crash. I remember when this crash occurred and I thought, oh my goodness, that's not going to be good. And clearly it was not. If the maintenance was truly faulty, then the trucking company should have also been charged in this particular case. Now, 110-year sentence. Clearly, this is a case that was more than likely required jail time. And I mean prison when I say jail. It's going to require that. You have 4 dead people and others injured because somebody was at a minimum negligent as it relates to the accident. Now, the district attorney in this particular case, Alexis King, was not the district attorney when the charges were filed, but she was the district attorney when the case went to trial. I think this is a classic case of the prosecutors overcharging a case. They could have charged vehicular assault. They could have charged carelessness resulting in death. Now, according to a statement put out by the district attorney, as well as comments by Mr. Aguilera-Mederos' attorney, the parties were never close. The district attorney made an offer of 20 years in prison for the death of these 4 individuals. Mr. Aguilera-Mederos wanted basically a traffic ticket. I'm not sure why the parties could not have come to the conclusion that something was reasonable in this particular case. And I'm sure Mr. Aguilera-Mederos' attorney advised him of the consequences if he went to trial and lost. The theory under which the prosecutor went forward on this was basically first-degree assault, extreme indifference, that he basically knew there was a risk and completely ignored it and basically said, the hell with everything, let's go for it. I think the case would have been more appropriately charged under vehicular homicide, basically the same theory. But they did this, and this is not uncommon, for the prosecutor to overcharge the case so that people don't go to trial, because if they go to trial and they are in fact convicted, then they will spend a significant amount of time in custody. And in this particular case, Mr. Aguilera-Mederos is looking at spending, for lack of a better term, the rest of his life in prison. So, who's to blame? I'm not sure. Take a look at this video. Let me know if you think this is good, safe driving and you can clearly see the truck ramp that he avoids. Did the defense attorney maybe not push the client a little harder to take the deal? Was the district attorney being unreasonable? If they thought 20 years was appropriate, why did they continue with the most serious charges of first-degree assault and attempted first-degree assault? Because that's what they do. They, being the government, has to pressure people into going to trial because, well, that's the way they get people to plead guilty, twisting their arms. So when people say being a district attorney is all about justice, let me know. Now understand, they're victims in this particular case as well. Those 4 families may think that 110 years is just about appropriate when something could have been prevented. Leave me a comment below. Let me know what you think. Welcome to the program. Let's get to the docket. First, Rohel Aguilera-Mederos. That's right. He is the truck driver who went careening down a busy highway here in Colorado, down I-70. Ultimately, his truck came to a stop where the brakes had failed by hitting several cars, and 4 people died. In fact, they died by burning to death. Well, by today, this morning, 4.6 million people have signed a petition that's asking the governor of the state of Colorado, Jared Polis, to grant clemency to Rohel Aguilera-Mederos or commute his sentence to time served. Now, as you may recall, Aguilera-Mederos was charged with 27 counts of vehicular assault, reckless driving, plus additional charges that were mandatory sentencing charges. On December 13th of this year, he was sentenced to 110 years in prison. A lot of that had to do with the fact that the court gave him the minimum sentence based upon the charging decisions of the district attorney. Now, the district court judge who handled the matter, Bruce Jones, who actually sits in Denver but was sitting on the case up in Jefferson County by assignment in this particular case, said that the sentence was the mandatory minimum that he was required to give under the state law. And he stated, quote, "I will state that if I had the discretion, I would not impose this sentence." That's what the judge said. Now, something that I've never seen before and under Colorado law is if somebody's sentenced to a crime of violence, you can request a hearing within 121 days so that the Department of Corrections has times to evaluate all the needs of the defendant in custody. I've never seen a district attorney join in any such motion, let alone file one on their own behalf. So the newly elected DA, Alexis King, filed a motion, even though she's the one that prosecuted the case, not her directly, but her deputies did. and said that after sentencing, she would welcome a reconsideration of the punishment, but she also said he didn't accept efforts to negotiate a plea deal and that the convictions recognized the harm caused to the victims of the crash. And as I stated, Governor Polis' office has received a clemency request and is reviewing that request literally as we speak. Now, Gage Evans, the wife of one of the 4 people killed in the crash, said the sentencing laws should be reviewed, but this sentence should not be commuted, which is the whole point we've talked about. Obviously, a lot of people think 110 years to a young 26-year-old person with no criminal history whatsoever, which some people consider to be an accident, is excessive. But the family members think that it's absolutely appropriate. The family members go on to state that he was found guilty of the reckless behavior that killed their family members and the most important thing in their lives. We'll see what the courts do. Obviously, a lot of people are supporting this young man. Tough case for sure. All right, let's get to the docket. First, the jury just came back in the Kim Potter case. That's right. She's the officer now convicted of recklessly killing Daunte Wright. And guess what? Sentencing is set for February 18th. She faces 86 to 103 months, although it could go as high as 15 years because of some aggravating factors that the court may have to take into consideration. This was a case where obviously not a lot was in question as to what happened. It came down to a lot of legal analysis. The longer the jury deliberated, more likely it was not going to be a defense verdict in this particular case. As you may recall, the jury came back the other day and said, hey, we think we're deadlocked. What should we do? The judge sent them back to conduct further deliberations. And, well, they ultimately reached a unanimous decision of finding Kim Potter guilty of both counts. Count 1, the reckless manslaughter, as well as the negligence theory as well. Both of those counts will run concurrent for sentencing purposes. And as I stated, the presumptive range, 86 to 103 months, 15 years, up to 15 years for aggravation. The judge is going to be able to consider some variance in this particular case because, well, let's face it, Kim Potter's probably not a threat to the community. She lived a law-abiding life for the last 49 years, 26 of which was as a police officer, and then she had obviously one bad day. Sometimes people forget. I try to remind people that all the time, given the work that we do, how quickly one's life can change. This is a classic example of it. And I've said this before, if your life was a big old movie reel, they would spread it out and they would splice out that portion of that bad day, and the jury has to consider of that information right there. Did something happen or did it not? Not whether you're a good person, whether you're a bad person, but whether the acts occurred. And in this case, the jury said guilty. We want to wish everyone a happy holiday, a Merry Christmas, and we will see you all next week. Have a wonderful holiday. Thanks for watching. We'll see you next time on Crime Talk.